Hello everyone, welcome to Master's Teach. And today we are going to discuss business environment, in which there are second, third and fourth and fifth unit are there related to the company's law, in which we'll discuss about the company's law and various things. Okay, if you are doing MBA, do. Watch this, and it is very essential for you. We'll discuss in this particular class business law essential, in which business like India's Companies Act and Contract Act, Insolvency and Intellectual Property Rights. Okay, it's quite lengthy one. Okay, so watch this. If you have any doubts, you can comment in the box so that I will reply the same. So today what we're going to cover. Okay, of course, is it visible to all? Right? Voice is clear? Right. We'll discuss about the Companies Act 2013. Okay. In that, we'll discuss about the incorporation, key documents like Memorandum of Associations and Articles of Association, share capital and governance, and Indian Contract Act 1872. In this, we'll discuss about the uh, elements like acceptance, consideration, remedies, and insolvency and bankruptcy code 2016. Okay, CIRP, then liquidation, NCLT and NCLAT procedures, then intellectual property rights, including trademarks, patents, copyrights, designs, and data protection. Okay, so let us start with the Indian Companies Act 2013. Okay, it was previously there. It was Companies Act 1956, and it is reforming same. So Indian corporate law, it governs the company incorporation, like starting of the company functioning and how to close or winding up the class. So the key focus we are going to discuss in this particular act: how to company formation, what is the structure, what is the governance and compliance, and this particular Companies Act 2013 says that it is the Ministry of Corporate Affairs which regulator body of Indian Companies Act 2013. Okay, when you are writing, write properly with the proper headings and all the stuff. So incorporation of a company, that means how to start a company, what is the required document. Okay, it is clearly mentioned. It is a step by step procedure. First you need to have digital signature certificate. Simply we say that DSC, and director identification number. Okay, that is DIN. Name approval, then memorandum of association, articles of association, then uh, professional declaration and registered of office proof. So these are the required document in order to incorporate the company or start a company. So this process, in order to start the company, the process will take at least 10 to 15 days. The company is registered with the Register of Companies under Register Companies Act 2013. Okay, so what is the memorandum of association? So memorandum of association is the company's like constitution, how the Indian constitution we have. In the same way, the company have their own constitution, in which it says about the scope, fundamental, and conditions and incorporation. First, in the first place, says that name of the company, name clause. What is the name of the company? If it is limited company, ending with the limited, and if it is private limited company, the name ending with the private limited company. And registered office clause, where the registered office is there, that need to be mentioned. Then objectives of the class, main class and other companies objectives. Liability class, members liability is limited. Okay, then capital class, authorized capital, share capital and its divisions. Then association class, so it is a surprise declaration to form the company. So these are the memorandum of association. When what is the clauses, you have to mention these six clauses in a memorandum of association. Okay, you can write or take the screenshot, then that will be helpful to you. Then articles of association. What is the articles of association? It is like when the company's formation takes place, there is an internal document how to manage the company. It defines the rights and duties of directors as well as shareholders. So the key difference between memorandum of association and articles of association, we already discussed about the memorandum of association. Now we'll discuss articles of association. Let us have some clarification. See, it is the main, the memorandum of association is a main document that is also called as charter document, whereas articles of association, it is the internal rules and regulation. So memorandum of association says that defines the scope and objectives, whereas articles of association about the management procedure in the internal company. Then this memorandum of association is mandatory for all the companies. Then it is optional. Okay. Then subordinate to Companies Act. It is also subordinate to Memorandum of Association Act. Then it is a default to amendment, and it is very difficult to change in the Memorandum of Association, whereas Articles of Association easy to change or amendment. I hope this is clear. Articles of Association and Memorandum of Association. Okay, we'll discuss types of companies. So, like Indian Companies Act 2013, the types of companies divide into four types. One is private company and public company, then one person company and government company. So, the minimum persons in private company to maximum 200 people can be joined. No public share, only for the private people, and the name ends with the private limited. And public limited, minimum 7 persons and maximum no limit, and number of people can join in the company, and they become owners of the company. They raise the cash or capital from the public, and the name ending with the limited. So one person company means only one person is there. For that, nominee is required. Okay, for it is entrepreneurs as well as for the startup, it is called as one person company. Then government companies, for example, if the company shareholds held by the central or state government more than 50%, 51%, that is called government company. ONGC, BHL, okay, like HMT. So these are called as government companies. So these are types of companies. And share capital and types of shares. So the share capital represents the funds raised by the company through shares. Okay. Types of share capital. One is authorized by capital, which is mentioned in the memorandum of association. That is a maximum capital. And issued capital. So in the part of authorized capital, which is issued, that is authorized capital. Then subscribed capital. So when the amount is subscribed or the shares are subscribed by the people, that is a part of issued capital. When paid up capital, amount paid by the shareholders or collected by the company, that is called paid up capital. Then types of shares, we already knows, it is very easy. Equity shares and preference shares. Broadly we can divide. If equity shares have the shareholder, they are right to participate in voting, and they will get the variables dividend and residual claim. Whereas preference shares, they'll, the dividend is fixed. Even though company get loss or less profit, they have to get the fixed dividend. Whereas uh, in preferential, they will get the priority in repayment of voting rights. Preferentials don't have rights in voting, but equity shareholder have the right to vote in the annual general meeting. So these are the share capital and types of shares. I hope you're able to understand this. And board of directors. Okay, board of directors means they look after the company affairs. So these people are elected by the shareholders with the have the some duties. Okay, appointment and qualifications. So minimum qualification, that you should have the director identification number, that means DIN, and at least you should finish minimum 18 years old, not disqualified per section 164. Appointment process, these are uh, these people are appointed in the annual general meeting. Okay, and board appointed as per the subject to the shareholders approval. Types of directors: one is executive director, then non-executive directors, independent director, nominee, and managing director. These are the types of director. If you write all these, you're going to get the full marks. Okay, just listen the class again and again, that will be helpful to you. Okay, then company meeting. So there are meeting how they are going to conduct in the this particular one. Formal gathering is the company decision with the procedure mandated by the Companies Act. As per the Companies Act, the company has to conduct the meeting compulsory. One is annual general meeting. Yearly they have to conduct at least two meetings. Within 6 months of the first 6 months of the company started, they have to conduct the same. Okay, and in which they are going to declare the dividend, director appointment, and for the notice should be given in order to conduct the meeting 21 days notice period. Extraordinary general meeting, simply we can say this EGM. It is a urgent matters between annual general meeting. In order to, like, in order to appoint, in order to make any special decision, they will conduct this extraordinary general meeting. So board meeting, is where directors are meet to discuss the company's management. Minimum 4 meetings need to be conducted in a year. The gap should be at least 120 days gap, and 7 days notice period will be given. These are the company meetings: annual general meeting, extra general meeting, and board meeting. Okay, then Indian Contract Act 1872. So this act, India's primary contract law, it's outline the valid agreement and remedies for breaches. Okay, so section 2H, an agreement enforced by the law is a contract. What is the contract? An agreement enforced by the law is called as contract. Contract required enforceable agreement. There should be offer. Somebody should offer that contract. One has to accept. Offer and acceptance is required. Whereas all contracts are agreement, but not all agreements are contract. So remember this point. Okay, we'll go to swiftly to the next slide. Okay, essentials of valid contract. What should be there in a legal contract? So in order to legally enforcement, the agreement must meet the following 10 elements. We'll discuss quickly. One is offer and acceptance. So there is a clear proposal from one side and acceptance from the other side. Intention to create the legal relationship. That is not the personal relationship, it is a legal relationship. Then lawful consideration. So legal values and consideration must be there. Capacity of the partners. They should have the 18 years of age. Plus sound mind means it should be mentally fit. Then free consent. There should not be any force or fraud. Lawful object. In order to conduct, what is the motto? It should be legal and moral objective. Not declared void, expressly void, it should not be there. Then certainty and possibility. The terms and conditions should be certain, we should be able to perform. These are the essentials of valid contract. They may ask, what is the essentials of valid contract? You have to mention these 10 points. Okay, of course, am I going slow or fast? I think it is very fast. Let me reduce the speed. Then offer and acceptance and consideration. Offer means a proposal made by one party to another party to do, abstain from doing something, or do something. Okay, it must be clear, communicated, and show the intent to create the legal entity. Okay, example: offer to sell his car to B for 5 lakhs. They may be offer, there is, they may be offer to do or abstain to do. That we called as offer. Okay, acceptance means, so assistance given by the person to whom the personal proposal is made must be absolute, unqualified, and communicated. Okay, that means B agrees to buy the car by 5 lakhs. This is called as acceptance. So you have to mention the section 2B, 2A also. Offer for the 2A, of acceptance for the 2B. What is consideration? So like something in return. So we give the car, what you are going to give, that is called consideration. Okay, the price paid for it. Consideration means something is written, okay, for the price is paid for it. Types of consideration: executed, like act done for promise; executory, promise for promises; past, act done before the promise. So example, 5 lakh is for the consideration for the car. So no consideration, no contract. There should be a consideration, there should be a payment, there should be a contract, okay. And that's the thing. For example, no consideration, no contract. For example, exceptions uh, imaginary things, natural love, time based debate, okay, debt, agency, something like that, okay. That is no consideration, no contract, okay. We'll go to the capacity and consent legality. Capacity means the person who entered into the contract, at least they should not be a minor, means that person should not be below 18 years, okay. It should not be unsound mind, means it should not be a mentally person, okay. Those who disqualify the lack of contract capacity, and section 11 specifies the competence. It should be a competent one. Then free consent, there should not be any force. It should be entered at free will, okay, not caused by coercion, means force. Undue influence, means you cannot influence by fraud or misinterpretation, giving misguidance or mistakes. If it is not free, the contract is void. That means that is going to be cancelled, okay. Legality of object: the object and consideration must be lawful. Unlawful, if forbidden by law, fraudulent, immoral, against public policy. So there should not be any illegal things or fraudulent things. So that is the thing. So example, the case is Mohari BB versus Damodas Gose established the minus agreement is void, AB into. So minus cannot be entered into the agreement, or this is the thing, okay. Then we'll go to the performance and discharge of contract. So performance of contract means contract are performed by the parties. Either actual performance, means both the parties fulfill their obligations. Then attempted to perform, one party is ready, another party is refuses, that is attempted to perform. Then by whom? Promiser, agent, or legal representative. Time and place, as per the agreement, reasonable time and place should be mentioned. Discharge of contract, that means how the contract is going to be cancelled, okay. Contract end via performance. If the actual performance is done, if the work is done, then agreement is going to be cancelled. Agreement, mutual people should have agreed for that. Impossibility, that means subsequent impossibility or frustration, that's the thing. Breach, actual or anticipatory breach, you can breach or cancel the contract. This is the performance and discharge of contract. I'll finish up as soon as possible, you don't worry, okay. Breach of contract and remedies. So breach of contract occurs when the party fail to perform obligation. So the aggrieved party entitled to legal remedies. One is damage, when the monetary damage and compensation for losses suffered, ordinary, special, or vindicate normal. This is the damage. Then specific performance, court order sometimes. So typically undue goods when money is inadequate. Injunction, court issues the order to prevent the action used to stop negative or covenant breaches. Then quantum merit, as much as an payment for work done when contract is breached as void. Uh, Rescission means contract is cancelled, parties restored to original position, so available for misrepresentation or fraud. These are the technicalities. You have to go through this very slowly. Then it is a unit 4 of environmental business, okay. So insolvency and bankruptcy code 2016. So see, IBC means Insolvency and Bankruptcy Code 2016. Okay, so like Insolvency and Bankruptcy Code 2016 consolidate insolvency and bankruptcy laws for companies, firms, and individual aiming for bond and resolutions. Okay, the key objects here: minimize asset values, promote entrepreneurship, balance interest of stakeholders. Then time bond, that means CRP must be completed within 330 days, including litigation, creditor control, shift control from debtor to creditor during the insolvency. This is just remember the Insolvency and Bankruptcy Code 2016 and these points. Okay, corporate insolvency resolution process, simply we can call it as CIRP. Okay, CIRP is a time bound process in corporate debtors, uh, initiated by financial creditors, operational creditors, or corporate debtors. Okay, when the application is filed, the file application with the NCLT, then NCLT admits the same, then uh, moratorium will be done, then IP appointed, then committee of creditors established. So this is the thing about the insolvency resolution process. Okay, corporate in, insolvency resolution process. They may ask about the CIRP. Okay, so liquidation and adjusting authority, how the liquidation process and what is the adjusting authority. Liquidation process says Companies Act 2013 section 33 and 53. Liquidation is ordered by the resolution plan failed to or violated. So liquidator sells assets and distribute the proceeds. So liquidate means closing of the company, in which the things is going to happen like this. First, insolvency resolution process cost, workmen dues within 24, secured creditors, unsecured creditors, government dues, and shareholders. These are the priority. The amount will be goes pays them. So voluntary liquidation, as per the Companies Act 2013, section 58 to 60, solvent companies can wind up within the 75% shareholders approval. They can voluntarily approve the like liquidation of the company. The approval must be 75% of the shareholders should be there. Then adjudicating authority, that is NCLT, that means National Company Law Tribunal. uh, Adjudicating indicates insolvency for companies, LLPs across 15 benches. Then NCLT, National Company Law Appellate Tribunal, hears the appeal from NCLT orders based in New Delhi. Then fast track process for small companies and startups, whereas assets and turnovers very limited, it is going to be completed within 90 days. Then pre-pack insolvency for the medium and small industries, MSME. So resolution plan for the pre-CIRP, offering faster, less disturbed and resolution. Okay. So intellectual property rights. Okay, IPR. Okay, it protects the intellectual property rights. Okay, like literary works. This intellectual property rights for the literary works, designs, and names. Then fostering innovation, granting the exclusive right for creators. Trademark and patents, copyrights, industrial designs, geographical indication, then data protection. We'll discuss what is trademark. Trademark means distinctive sign or identifying like goods and services registered under Trademark Act 1999, valid for 10 years. It can be renewable again and again. So remember this. Patent, it is patent means exclusive right for inventations under Patent Act 1970, valid for 20 years, must be novel, inventive, and industrially applicable. The patents. Okay, then copyrights, it protects about the literary works, about the literature, artistic and musical works. So the Copyright Act 1957 lasts for creators lifetime. So copyrights is there up to lifetime of the person who create the same. And it will be like after 60 years automatic upon creation. Then industrial design, so it protects the proper Industrial Designs Act 2000, okay, valid for 15 years, must be renew and original. Then geographical indication, this is a type of property, intellectual property rights, identify goods from specific region, okay, that is called GI Act 1999. Example, Darjeeling tea, basmati rice, etc. And Telangana have also certain type of things. Then data protection, Digital Personal Data Protection Act 2023, which protects the personal data, ensuring that privacy and rights, and regulating the processing. So this is about the intellectual property right. You can expect these things in your UGC net as well as MBA examination. So concentrate on this intellectual property rights, liquidation process and adjecting authority you have to learn, and you should know about the corporate insolvency and resolution process. Then bankruptcy code you should know. Then breaches of contract, performance and breaches, okay, capacity and consent legality. Then offers acceptance, essential elements of valid contract. Then Indian Contract Act 1872. These are you should know. Different types of company, different shares, okay. What is memorandum of association, what is articles of association, how the actually the company formation takes place, okay. So these are the things which I covered: Indian Companies Act 2013, Indian Contract Act in 72, Insolvency and Bankruptcy Code 2016, then intellectual property rights. So go through this video again and again and share with your MBA friends, and that will be helpful to you. Then we'll meet the next uh, with the next chapter, and probably on Monday. All the best for your coming examination.